Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Motor Vehicles Amendment Bill, which seeks to increase the penalty for traffic violations. To discuss the issue, I have with me Dr. Shamla Pappu, Senior Advocate, and Mr. Satyendra Garg, Joint Commissioner, Delhi Police. Now for the headlines. Drunken driving to cost you more. Bill proposes fine up to 5,000 rupees. You may be able to get refund of unutilized road tax if there is a change of address. And bill seeks to empower traffic police to suspend license on the spot if you fail the breath analyzer test. Drunken driving could cost you dearly now. The Motor Vehicles Amendment Bill 2007 seeks to impose up to 5,000 rupees as penalty and cancellation of license if you are caught driving after consuming alcohol. The government also seeks to increase fine for almost all traffic violations.
The Global Status Report on Road Safety by World Health Organization highlights India having the highest number of road accidents in the world. According to this report, speeding, drunk driving, and low use of helmets and seat belts in the vehicles are the main factors for accidents. After being deliberated for nearly 5 years, the proposed Motor Vehicle Amendment Bill has started taking concrete shape.
If you want a good traffic system, so basically your laws and rules should be so strict and so non-sparing that people by nature become rule compliant. But within our city and country, like people generally defy or say flout the rules, thinking that number one, he will not be caught, and even if he is caught, like penalty structure is so meager that maybe like he can afford it.
After the Standing Committee's input followed by the Law Commission recommendations, the Cabinet recently passed the final proposed amendments to the pending bill. Now, for dangerous driving, there will be a fine of 5,000 rupees and imprisonment of 2 years if the offence is repeated. The existing law provides for a fine of 1,000 rupees and 6 months imprisonment. If you are caught over speeding, the fine ranges from 400 rupees to 1,000 rupees for the first offence, which can go up to 5,000 rupees for the subsequent offence. The existing law provides for a penalty of 300 rupees. If you are caught jumping red lights, not wearing seat belts or helmets, you will have to pay a penalty of 500 rupees for the first time, and repeat of the same violation will result in increased penalty up to 1,500 rupees. Currently, the fine for these violations is 100 rupees each. According to the proposed amendment, the use of mobile phones or iPads while driving will attract a penalty of 500 rupees for the first offence and 2,000 up to 5,000 rupees for the subsequent violations. These include everything from talking on the phone, sending messages, listening to voicemails, and use of hands-free. The existing penalty is 100 rupees. The bill proposes categorization of drunken driving. Now the penalty for drinking and driving ranges from 2,000 rupees to 5,000 rupees and imprisonment of 6 months up to 2 years. The existing law has a penalty of 700 rupees.
Either way, whether the victim if the victim is deceased, the family will get redressal in the form of a minimum amount of compensation in terms of the second schedule, because even if they move court and they fail, they will still be entitled to compensation in terms of the schedule which has been prescribed.
The bill also seeks to change the method of awarding compensation for motor accident claims. If the fault of the driver is sought to be established, the claim has to be decided by the civil court or motor accident claims tribunal. If the claimant does not seek to establish the fault of the driver, compensation shall be based on the victim's income and age. The Cabinet has given its final nod to the proposed amendment in the Motor Vehicle Act.
but it's always the public call that what is important for them, the safety or the convenience. With camera person Chetan Beer, Aruna Thakur, Rajya Sabha TV.
Any authority empowered to check a driver's license can suspend it on the spot if the driver fails a breath analyzer test. The bill does not specify either the process by which a driver can defend himself or that of appeal. Dr. Shamla Pappu, first of all, empowering the traffic police on the spot with suspension of license. Let's suppose a situation where a person has not actually had alcohol but gets into an altercation with the traffic police. What happens in a situation like that? Is it proper? Are we prepared to empower the traffic police on the road with such a huge power?
It is a very arbitrary sort of power, if I may say so. And of course, I am sure a notice will be given to the driver. Immediate suspension means not suspension for all time to come.
3 months.
3 months. But even then, not exceeding 3 months, the bill says. And the driver, I am sure, will have should have an opportunity to defend himself. He can be asked, given a notice, to appear and then put forth his case.
Right. The Joint Commissioner, sir, how would you, do you think we are prepared, the people under you who have largely over the years become professional in various ways, but still there's a lot that is desired. Do you think it's all right on the spot to empower him?
See, rather, if you want a good traffic management system, I think this is the need of the hour. I'll elaborate by saying that, like, see, alcometer test is a scientific test. It's not arbitrary, like you say that you have failed the test. There is always a printout given to the person whose breath analyzer test is there, and one copy goes to the court. So, to me, I think it makes perfect sense that if you have failed the test, I think your driving license should be suspended immediately till the proceeding. Of course, like next day, like we send the case to the court. If he alleges something which is not fair, I think I am sure very next day he can complain to the court. And like we are prepared as a professional police, like we are prepared for this scrutiny. Like what we have done of late is this precisely, because previously till 2010, the drunken driving case used to come about 6 weeks after the incident. What we have done is, in collaboration with the court, like we have impressed upon the court that drunken driving is something very serious. So, for last about 2 years, what is happening is, if you do the drunken driving test, say like we did it yesterday, today morning 10 o'clock, the person who has failed the drunken driving test is in the court. So, the printout is given on the spot to him, and a printout of the alcometer test goes to the court.
Attached. And that is how the action takes place.
Yeah, and if he has got anything to complain, I think I am sure he will complain at the first opportunity when he goes to the court.
Are you quite sure the magistrate will be there the next morning?
Yeah, no, next morning means next working day.
Or the court might not function for one reason or the other till such time his license will be suspended without a hearing. That is what I think Mr. Amritanshu is trying to emphasize.
Let me complete. See, like the situation here in Delhi is next working day, like some duty magistrate is always there. What we have done is next working day, like if we do it on Saturday night, then Monday morning, like regular courts, traffic courts sit.
That's the implementation part. It is happening. So, the whole point is that there has been an improvement on the activity which follows the action of detecting. Right. I'm saying, anyway, you've made your point, ma'am has made her point. I wanted to come, you've said non-sparing laws should come into force versus compensation. The way compensation is, the issue of compensation is dealt with, it's a pretty complicated way in which a person seeking compensation will have to go about in order to get compensation in the amendment bill. But as far as the non-sparing bit is concerned, it's very well established. That's
so
the
that
pith
is
and
my brief
substance.
at this moment.
So you have succeeded, but we or others who are traffic violators, not me specifically, but others who are, will not be able to get compensation in situations of accidents or others as easily as it is right now. Is
May
that
I
so?
answer that?
Yes, ma'am.
You see, in Delhi, there was an amendment in 1994 to the Motor Vehicles Act, and 158(6) was added, and 166(4) was added to the Act. And that said that it's the police that will collect all the evidence.
All onus
the
is on the
evidence police will collect, and because the victim is already suffering, he doesn't know whether he is coming or going. If the man is dead, then it's much worse. His relations are sitting and crying, they don't know what to do. Then how are they going to collect evidence? How are they going to make the claim petition? Therefore, what was evolved was that the police will collect all the evidence, certificate of registration, damage to the vehicle, the damage to the person,
Mr. Garg, do you think that is happening? What
Yes,
the judgment that Dr. Pappu is referring to, is that in implementation?
See,
Yes,
in Delhi, it is perfectly happening. Like we have now gone even to the public, this one, like on our website, there is a special site created for only accident tribunals. Now, insurance company can go on to this one. Every accident case, like progress, up to date progress, the moment FIR is registered, then progress of the case, like you make 174 this one proceeding if it is a fatal accident, or say like collection of MLC, everything is on board now. Like you can see on, say, the copies are uploaded for everybody to see, insurance company, the victim, and of course we collect, and we are bound to present our the case within 60 days to the court, and we are doing it. I mean, only in those cases of hit and run where, see, like nothing is available.
Investigation is required.
Yeah, so like except in those cases where progress cannot be made, I think all available documents are made available to the victim and his family.
But Mr.
On that
Garg,
note, ma'am, on that note, it's time for us to head into a break. When we come back, we will talk about several new features of the bill. Welcome back. The Motor Vehicles Amendment Bill 2007 seeks to allow refund of unutilized road tax deposited with the government at the time of registration of vehicle. This will be allowed in case of change of address of the vehicle owner. This provision was not there in the existing law. The bill has several new features.
Overloading of transport vehicles is one of the major dangers to the road safety and longevity of road infrastructure. Keeping this in mind, the bill seeks to include consignor accountable besides driver or the owner of the vehicle for overloading of transport vehicles.
We are also looking at asking the states to create state level road safety funds in each of the states, wherein 50% of the amounts that are being levied by way of penalties and fees under the proposed amendments goes back to this dedicated corpus of the state road safety fund. That money can be utilized for the back-end infrastructure creation of e-challan systems, for better enforcement in terms of your speed guns or breath analyzers and interceptors, that you don't have to fight for funds in order to do enforcement on road safety issues.
The bill proposes several new changes in the law. The state governments will be empowered to authorize automobile association and institution to issue driving certificates which will exempt a person from driving test. Earlier, only the authorized officer could issue licenses. The bill lays out a timeline of 45 to 60 days for disposal of appeals. The existing law does not have any timelines. Now insurance company will be able to become parties to the claim after permission of the court. The existing law does not have the such provisions. The proposed bill empowers the traffic police to suspend the license on the spot for 3 months for drunken driving. The existing law does not have this provision. The bill seeks to allow refund of unutilized road tax deposited with the government in the case of change of address of the vehicle owner. This provision is not there in the existing law.
Hit and run accidents are concerned, where vehicle owners cannot be identified or the vehicle cannot be identified. The new bill also takes care of that. And in fact, for the first time, a solatium fund has been set up. that Solatium fund will pay a minimum amount of ₹1,00,000 or ₹1,50,000 for a death, and 10,000, 15,000, 20,000, whatever is prescribed for those who are victims of hit and run accidents.
The bill increased the powers of the state governments in the matters such as regulating stage and contract carriages, service operators, and creation of authorized testing stations. Now the state would be empowered to restrict the number of stage carriage or contract carriage permits in cities.
The bill proposes higher penalties to the traffic rule breakers. But will it reduce the road accidents is still remain a question. With camera person Chetan Beer, Aruna Thakur, Rajya Sabha TV.
The bill seeks to absolve the insurer from liability in case of an accident where the vehicle was being driven by a person without a valid license. The standing committee, the parliamentary standing committee, recommends that if an insured vehicle commits an accident, the insurer may be held responsible as per the insurance policy, irrespective of the fact that the vehicle was driven by a valid license holder or not. The question to you, Mr. Garg, do you think the standing committee is correct in its assessment that whether a person with driving license, without driving license, it is driving the car, it is the car which is insured, and if an accident happens, no matter what, the insurer must stand by the commitment of giving the policy? Do you think that's correct, or should it remain the way it is proposed in the bill, which means the insurance party goes scot-free?
See, I look at this way, from the victim point of view, what is important is he needs compensation. Okay, so insurance company, of course, cannot escape the liability. Of course, there is a provision that suppose somebody without valid license. So here, my view as a professional will be that victim has to be compensated, victim or his family has to be compensated. Insurance company, there could be a legality, because you presume that insured vehicle should be driven by the person who is authorized. In this case, I think I would like to stress one thing more, that the person who is unauthorizedly driving has to be given exemplary punishment. And if some sort of compensation can be extracted from the violator, that also should be there, because apart from imprisonment, there should be a pecuniary penalty on the person who is driving.
Do we have it?
No, at this moment, it's not there. Rather, courts can definitely award in terms of imprisonment.
Right.
See, if I am driving a vehicle, I think it looks very strange that in India, we are still getting large number of cases where people are still driving without a license. So, this should totally disappear. How can one person come on the road, drive a vehicle without a driving license? Let me tell you, maybe in the entire world, this is unheard of, except maybe in our country, where if you drive without a driving license, penalty is just 500 rupees. I think it should be absolutely taken away, and the person who is driving a vehicle without license should immediately go behind the bars.
Dr. Pappu, the point is that the bill specifically says that if you are not authorized to drive, then no insurance claim, right? The standing committee says that's not correct. Insurance policy, the car is insured, and the insurer must stand to the commitment that it has given on the policy. The third aspect is, quietly, insurance companies have also been allowed to become party with leave from the court in any litigation relating to such matters. In such a situation, when they already have a forum and a way which was not earlier available to them, then don't you think it's proper to do away with the clause which says that no compensation in case of unauthorized
Well,
driving?
in all this, the insurer, the traffic police, law and order, the victim is being forgotten. Really speaking, we have to think of the person who is suffering on the road. There was a survey, and it was found that 38% of the vehicles did not have insurance at all, and they were plying on the road. There was a survey in 2009, and that was the report. And if 38% are applying without any insurance. What happens to the person who is on the road? So therefore, insurance should be made compulsory.
Is compulsory?
Should be made compulsory, and if I may say so, in South Africa and in Canada, insurance, third party insurance is deemed to be made. You don't have to go and take a policy for third party insurance. It is deemed. How? They have a fund which is created by adding a cess to the diesel and the petrol, by adding a cess to every car that is sold. That is put into a fund commissioner, he doles out the money to the victim, and every car, every vehicle on the road is automatically deemed to be insured for third party risk. This is the thing I think which we should achieve. Then issuing an insurance policy, etc., so many things will be reduced.
Right. On that note, ma'am, it's time for us to head into a break. When we come back, we will show you an interview with senior advocate Atul Nanda. Welcome back. My colleague Aruna Thakur spoke to senior advocate Atul Nanda and tried to find out if the bill is too late and offers too little.
So the bill has already taken care of its very important objective, that is higher penalties for the drunk driving. So how do you see the other objectives of this bill?
This law does not integrate the proper authorities either to curb the menace of accidents. Yes, an effort has been made definitely. Like for example, in 1999, it was public knowledge that drunken driving is a great menace. It's not that it was not earlier there. After a particular case happened, it came in public domain and everybody started thinking. Now we are in 2012. In 2012, government is still thinking how to curb drunken driving. And by what? By 6 months or 1 year or making a penalty. If you really ask me, this is a half-hearted attempt to correct something which is not correctable.
Sir, as you said that the compensation part is very crucial in this bill. So how do you explain this?
This bill creates a confusion. If you see the amendment to 163A, B and C, C says that if you have pursued a remedy under one, you can't do it under the second. That means if you are pursuing a remedy which is no fault, you can't come under the fault liability, correct? This is what is the mandate of 163C. But if you read 163B2, the proviso, which says that if you fail under a fault liability, you may come under a no fault liability. The nature of proceedings totally change. Therefore, it will be detrimental to the interest of either an insurer or the owner of the vehicle, because the scope of two proceedings are totally different. This is going to add a lot of confusion.
In case of the driver's fault is not established, the Principal Act specifies the amount of compensation. The bill changes this method and proposes to use a formula based on the income of the victim multiplied by a factor which is specified according to his age, which implies that there is no upper limit on the quantum of compensation which may be awarded. But going beyond the compensation bit, ma'am, driving certificates to be issued by associations and institutions to be approved by the state, and the state being empowered through this legislation, this amendment. Do you think that will help in increasing the number of licenses so that anyone who is doesn't have hold a license will now be able to get licenses easily, so now the entire process will be turned all the way around? Is that so?
There should be a mechanism which is now functioning from 2010 to 12, which is very recent, and Mr. Garg will bear me out, that there is this method of getting at compensation early, because police is asked to collect all the information in an accident, police is asked to collect, SHO is asked to collect all the information. Victim, his relations, what he did, what is the injury, what has happened, what has not happened, everything. And that becomes the claim petition. He presents this information into court, and that becomes the claim petition. Victim has to do nothing except go to the hospital.
There is that mechanism.
I'm going to add something there. When he goes to the hospital, he may not have money. So there has to be cashless
solution fund
for him for at least 72 hours, so that he is wide awake after that and he can take care of himself, and the insurance company should be liable to present this cashless medical facility to him for at least 72 hours.
One last word from Mr. Garg on this bit, ma'am. There is no provision to for a person who doesn't have a license. What is the existing punishment and penalty, and how do you think should it be enhanced, or so that driving without license is really not happening?
See, like at this moment, like if you are found driving without a driving license, I mean, though it looks surprising, the penalty is just ₹500 if you are driving without a driving license. I mean, I'll take on that question also about issuing of driving license. See, our problem in India is not that we are not able to get driving license. Rather, I'll say that our problem is that we get our driving license too easily. See, like whatever the method, whether association issues it or government machinery issues it, first thing you have to ensure is that the person should know rigorously how to drive. Then only, like I was told, like in UK, like you fail driving test maybe 15 times, then you get it. Here, like I mean, it's a known fact that you get a driving license without knowing how to drive it.
Perfectly. What is the solution you propose for ensuring it as a deterrent?
See, as a deterrence is simple. If you are found without driving license driving, straight away, like the person should go to jail and vehicle impounded. And like you should also ensure that if you are issued a driving license without knowing it, I think the issuing authority should be disbanded.
Okay. On that note, thank you, sir. Thank you, sir, and ma'am. That's all we have time for. So, joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new episode and a new issue. Keep watching Rajya Sabha TV.